In a house outside Detroit, someone lifts a couch cushion and finds a spiral notebook. Inside, in ballpoint pen, is the will of Aretha Franklin. That notebook sets off roughly 5 years of litigation over an estate worth about $80 million, and by 2020, the lawyers had already billed more than $586,000. Her own attorney had asked her for years to set up a trust. She never got to it. Here is what no lawyer tells you about the one she should have had, and she is not the outlier. Prince died in 2016 with no will at all, no spouse, no children, and a catalog worth a fortune. It took 6 years of court proceedings before anyone knew who owned what. Michael Jackson, Robin Williams, Jimi Hendrix. The same story with different music playing behind it. These were people with access to the best legal advice money can buy, which tells you something uncomfortable. The failure here is almost never a lack of information. It's a lack of finishing. You have been told a will protects your family. It doesn't. A will is an instruction manual written for a judge, and it does not avoid probate. It guarantees it. Probate is the court process that prees your assets out of your name and puts them into someone else's. And the American Bar Association puts the average at roughly 16 months and 3 to 8% of the estate. Picture a $500,000 estate. $15,000 to $35,000 evaporates before a single heir is paid. In California, they don't even hide it. The fee is printed in the statute. 4% of the first 100,000, 3% of the next, 2% after that. On a $1 million estate, the attorney's statutory fee is $23,000, and the executor is usually entitled to the same. $46,000 for moving paper. And the line at the courthouse keeps getting longer. Between 2020 and 2024, probate and estate filings jumped almost 32% across the states, tracked by the National Center for State Courts. Florida went from just under 58,000 probate cases in fiscal 2019 to more than 71,000 by 2024. California climbed from about 32,000 filings in 2016 to nearly 42,000 in 2025. Meanwhile, 56% of American adults hold none of the 5 core documents. No will, no trust, no medical power of attorney, no financial power of attorney, no HIPAA authorization. That figure barely moved between 2025 and 2026, and the reason is worth sitting with. Awareness is not the problem. Everyone knows they should do this. Nearly half of Americans say they feel more financially anxious than they did a year ago, and anxiety doesn't push people toward planning. It pushes them toward deferral. Estate documents feel optional right up until the morning they aren't. So you do the responsible thing. You get a living trust. Now here's the part nobody says out loud at the signing table. The document is not the product. The funding is the product. A trust governs exactly one thing. What has actually been retitled into its name? Nothing else. If the house is still deeded to you personally, if the brokerage account still reads your name, if the rental across the state line was never transferred, then that trust governs nothing at all. Your family goes to probate anyway, clutching a leather binder with gold lettering that does not work. Funding is not one signature. It's a new deed recorded at the county for every property you own. It's a retitling form at every bank and every brokerage. It's an assignment of your membership interest if you own a piece of a business. It's checking that the life insurance and the retirement accounts point where you think they point, because those pass by beneficiary designation and never touch the trust at all. Estate attorneys will tell you this is the most common failure in the entire field, and it is not a drafting mistake. It's an unfinished errand. The documents take 2 or 3 weeks. The retitling takes another month or 2, and that is precisely where people stop. Half-funded is worse than unfunded, because now the survivors are arguing about which assets the trust was supposed to catch, and that argument has a name. It's called litigation. And if you own property in more than one state and leave it in your own name, your family doesn't get a probate. They get one in every state where you own dirt. Separate courts, separate lawyers, separate clocks running at the same time. There's a quieter cost too. Probate is a public file. Anyone can walk in and read what you owned, what you owed, and who you left out. A trust is a private document that stays in a drawer. Now, the thing they undersell every single time. Everyone pitches the trust as a death document. Its most valuable day is usually a day you are still very much alive. A will does nothing while you are breathing. Nothing. If you lose capacity without a plan, your family lines up in front of a judge to ask permission to manage your own money. That's guardianship or conservatorship, and it's public, expensive, and slow enough to hurt. With a funded trust, your successor trustee simply steps in and pays the mortgage on Tuesday. No hearing, no stranger appointed to your life. And the odds here are moving in the wrong direction. In 2026, An estimated 7.4 million Americans over 65 are living with Alzheimer's, and that number is projected to approach 13 million by 2050. New dementia diagnoses are expected to roughly double between 2020 and 2060, from around 514,000 a year to a million. As capacity declines, two things happen at once. People become more vulnerable to whoever is standing closest, and every document they sign near the end becomes something a disappointed relative can attack later. But here is where people get hurt, and you need to hear this cleanly. A revocable living trust does not protect your assets from creditors. Not $1. Because you can revoke it whenever you like, the court treats everything inside as still yours, and a judgment creditor reaches into it exactly as if it sat in your personal name. The North Carolina State Bar says it without hedging. Any claim that living trust assets are shielded from creditors or from healthcare costs is simply incorrect. It does not cut your estate tax. Everything in it stays in your taxable estate, and the federal exemption is $15 million per person in 2026 anyway. It does not make you eligible for Medicaid. It's a probate tool and an incapacity tool. It is not armor, and anyone selling it as armor is selling you something else. Which brings us to the free lunch. The California Attorney General runs a standing public warning about what the state calls living trust mills. The choreography never changes. A free seminar at a church, a senior center, an assisted living dining room. A salesperson who calls himself a trust advisor, or a senior estate planner, or a paralegal. Then a follow-up appointment at your kitchen table, where the actual product gets sold. And the actual product is almost never the trust. It's an annuity with a surrender period that will outlive you, funded with the financial inventory you just handed a stranger. This is not theoretical. One California operation moved more than 10,000 trust packages and over $200 million in annuities before regulators shut the practice down, and officials admitted afterward they had no idea how many of those trusts were defective. That's the real danger. A trust that was executed wrong can be challenged, and a defective trust is worse than no trust at all, because your family only discovers the flaw during the worst week of their lives. Know your rights here. If you buy a trust in your own home or at a hotel seminar, you can usually cancel within 3 business days. If you're 60 or older and you bought an annuity, you have 30 days to walk away without a surrender penalty. The Attorney General is blunt on 2 points, and they're worth repeating. Not everyone needs a living trust, and anyone pushing a one-size-fits-all trust kit is waving a red flag at you. There's a mirror image of this inside the licensed bar. Since 2020, estate, trust, and probate work has generated the highest share of all legal malpractice claims in America, close to 14%. In Wisconsin, it hit roughly 18% of every claim filed in 2025. These are not fringe operators. These are attorneys with shingles out front, and the claims often surface years, sometimes decades, after the ink dried. Now follow the money, because the money explains the anger. An estimated $124 trillion will pass at death between now and 2048, with millennials alone inheriting somewhere near $46 trillion of it. That is the largest transfer of wealth in human history, and it's landing on families who have never once sat down and talked about it. The family math has changed too. The divorce rate for Americans over 50 doubled between 1990 and 2010, and as of 2022, 36% of everyone getting divorced is over 50. That means second marriages, stepchildren, and adult kids from a first marriage all standing in the same room with competing claims. Stepchildren are not automatically heirs unless they're legally adopted or specifically named, which is how people get accidentally disinherited by a document that was never updated. More money on the table. More people who feel entitled to a seat. More room for someone to whisper that mom wasn't herself at the end. That's the engine underneath the 32% surge in filings. So here is what a properly built trust buys that a will can never touch. Instructions. Not just who gets it, but when, how, and on what terms. Money held for health, education, maintenance, and support. A share fenced off for the child with creditors, or the child in a divorce, or the child fighting an addiction who should not receive a wire transfer next Thursday. Distribution staged over years instead of a lump sum handed to a 22-year-old. A buyout right so one sibling can keep the family house without 3 of them going to war over the kitchen. And a successor trustee with the authority to say no. A will does none of it. A will hands everybody a check and the address of a courthouse, and then it steps back and lets grief do the rest. So what do you actually do with all of this? Get the trust drafted by someone who has nothing else to sell you afterward. Ask directly whether they earn commissions on any product in the room. Then fund it, line by line, asset by asset, until the list is empty and the house, the accounts, and the business interests all read the trust's name. Align every beneficiary designation, because a retirement account beneficiary form beats your trust and your will both, and an outdated one sends your savings to somebody you divorced in 2011. Pair it with a durable financial power of attorney and healthcare directives, so the incapacity plan and the death plan are actually holding hands. Then tell your successor trustee where the documents live. A plan locked in a box nobody can open is treated by the court exactly like no plan at all. And review it. When the law shifts, when the family shifts, when the assets shift. 20 minutes a year. That's the whole discipline. Aretha Franklin didn't lack lawyers. She had them. She had one who told her precisely what to do for years, and she meant to get around to it. Everyone means to get around to it. That is why the notebook was in the couch. Your family will not inherit your intentions. They will only inherit what you finished.